Okay, well, let's start. I'm sure other people will come in. Glad to see you all here again. And I'm glad that this workshop is working. We've had a few challenges with other ones. So I'm just going to acknowledge that I am living and working on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh peoples, and appreciate their stewardship of these lands. If people want to put in a territorial acknowledgement or hello from their region in the chat, you can do that. But otherwise, I'm going to hand it over to Agnes. I think most of you know Agnes in her various personalities as I think a hippie and then Julia Child. This year, this is Agnes. Agnes is a family law lawyer, has worked for many, many years, and also does a lot of work with a lot of the groups that we fund at the Law Foundation, Battered Women Support Services, and the Children and Youth Legal Clinic for a couple. But I'll hand it over to you, Agnes, and then you can just start.
Awesome. Thank you so much, Lois. And thanks to Kayla also for helping me with my tech issues. I also am honored and grateful every day to be here on the unceded territories of the Squamish, Musqueam, and Tsleil-Waututh nations. And through my work and personal life, I also get to travel a lot to Sechelt Nation territories and also up in Tsimshian territories, which I will be in next week. So I'm just so grateful for all the welcomings I have across this land from the Indigenous peoples. And I hope to do right by them in my work and in how I am in this world. So thank you to all for being here as well. As Lois says, I'm a family law lawyer, and as always, I'm so excited to do these family law updates. I don't know if I'll get through everything because it's a lot of slides. And as you know, the Supreme Court of Canada for many years was just so quiet on family law cases, just nothing. And then in the last few years, we had Michelle and Graydon, then we had the Colucci ones on child support. And then, of course, this year, we actually had 2 decisions on the Supreme Court of Canada. I'm only going to really talk about one of them. But the other one, and I forgot about it, and then I ran out of time to do it. But I'm going to, when I do the PowerPoint, I'm going to put it in there because I just want to quickly tell you about it. It's called BJT and JD, and the Director of Child Protection for Prince Edward Island got involved as well. And it's an appeal out of a decision out of the PEI courts, which I don't know how many we see of those, but the interesting thing about it is the ministry basically interfered with a parenting regime between a father and the maternal grandmother, and essentially took the child away to Edmonton and supported the father having the child. Anyway, the nice thing is the Supreme Court of Canada gives a little bit of slap down to the ministry, which always makes me happy. So I will write a little bit about that. I just didn't include it in this PowerPoint. You probably know which case I'm going to refer to. It's called Barendret and Greblionis. Oops, that should say 2022. Wow. First page, an error already. Anyway, this is a big case out of British Columbia. It was a relocation case, and the choice was between Telkwa in the north-ish or Kelowna. And I don't know where you pick. So at trial, the judge allowed the children to be relocated to Telkwa with the mother. Then the BC Court of Appeal, it overturned that decision and held it was the best interest of the children if they stayed in Kelowna with both parents. Of course, that would force the mother to have to be in Kelowna when she didn't want to be in Kelowna. So it goes all the way up to the Supreme Court of Canada, and they allowed the appeal and restored the trial judge's decision to permit the mother to move to Telkwa. In fact, in the middle of the proceeding, she stayed in Telkwa because there was a stay. So the children got to experience their life in Telkwa through that proceeding. The great thing, of course, as you know, is that there were some really strong interveners involved, including West Coast Leaf and the Rise Women's Legal Center. Shout out to them. And their participation was very instrumental, as we'll get to in a moment. So at the trial level, it was Justice Saunders. Justice Saunders' primary concern was that If the mother stayed in Kelowna, she would be subjected to ongoing dynamics of abuse in light of the father's overbearing personality, his history of physically and emotionally abusing the mother, and the mother's lack of support system in Kelowna. Now, if you think back of all the cases you've done, how many relocation mobility cases have you heard where family violence really was acknowledged by the court as a ground in which to support the move away from an abusive situation, or that emotional support of the support system? That a little bit more, the court will acknowledge that, but certainly not family violence in the way that the court has now done in this case. So the Supreme Court kind of went back to the basics. Gordon and Gertz, most of you probably know that case. That's the sort of the seminal case on mobility. It's really old, as in 1996. That said, I'm much older than that case, but it's considered an old case. And, you know, through the years, 25 years plus, it's had some revisions done to it or different thoughts about it. So the first step, of course, is the court must consider whether or not there's been a material change of circumstances. And then the second step is the court then has to determine what order would best reflect the best interests of the child in the new circumstances. But ultimately, material change of circumstances or not, the court really comes down to the fundamental, the only thing that matters, which is the best interest of the child. That's the question, right? And the best interest of the child, as we will see, is also connected to the best interest of the parent who is parenting that child. So, as you know, there was a new Divorce Act that came out, it was amended in 2019, pardon me, came out last year. And it largely codified the Gordon framework. So basically, again, courts must consider best interest of the child, having regard to the child's physical, emotional, psychological safety, security, and well-being. And if that language sounds familiar, that is in the Family Law Act, section 37(3). So now, you know, we are getting court decisions and legislations that are more in line with each other in terms of addressing the best interests of the children. Of course, any inquiry about whether children should be relocated is highly fact specific, and it's a discretionary decision of the judge. And the court will consider factors such as, and these are again, the section 37(2) factors that we have in the Family Law Act: the child's views, preferences, history of caregiving. And on that note, history of caregiving, it has to be understood not just to be about the time in which a parent is parenting a child. It's also about the quality of caregiving. And so if you're ever arguing the case, you stress that as well. It's not just, oh, well, he has, you know, half the time, but it's also quality of time that and the history of the caregiving that if you're arguing these cases, that's, you should think about that as in terms of bolstering this factor. And then, of course, any instance of family violence and the child's cultural, linguistic, religious, spiritual upbringing. Oh, apparently, my apologies. My Zoom thing went off. It's trying to make me leave the meeting. No, okay. The court also considered each parent's willingness to support the development and maintenance of the child's relationship with the other parent. And as you know, that's attached again in section 37(2) of the Family Law Act. The court must give effect to the principle that child must have as much time as possible with each parent as it's consistent with the child's best interests, maximum contact principle. And then this is a big one. The child should not consider whether parent who intends to move would relocate without the child. That's a double bind that we put parents in. You can't ask that question. So again, this is consistent with what is in the Family Law Act in terms of the best interest of the child. The great thing about the Supreme Court of Canada's decision was how much it had to say about family violence. Like, it was unequivocal in terms of, it was so strong, actually. And so the court noted, and this is from paragraphs 142 to 147. There's a lot of references in the paragraphs, but I've taken those out. So since Gordon, so that's 25 plus years ago, the courts have been increasingly recognizing that any family violence or abuse may affect a child's welfare and should be considered in relocation decisions. I don't know if that's really true. I mean, I've done many cases where I don't know if it's really true that family violence really comes into it. But anyway, good thought. And we keep pressing. It's good that the Supreme Court states that. It's like, this is what it should be. And so they have been more likely to allow relocation where there's a finding of abuse. And then again, the suggestion that domestic abuse or family violence has no impact on children has nothing to do with the perpetrator's parenting ability is untenable, right? Great statements, right? And again, it says research indicates that children who are exposed to family violence are at risk of emotional and behavioral problems throughout their lives. Wow. Haven't we all said these things so many times over and over? Domestic violence allegations are notoriously difficult to prove. We know that. And then they reference Leaf and Rise, noting that family violence often takes place behind closed doors and may lack corroborating evidence. So, and then the prospect that such findings could not necessarily be relitigated on appeal will often deter abuse survivors from coming forward. So as it stands, the evidence shows that most family violence goes unreported. This is the Supreme Court of Canada acknowledging in a very strong way how family violence works in the system. I know they don't specifically make it gendered, but I think it's very clear in terms of who is the survivors in most of these circumstances. So again, the decision talks about how the Divorce Act has been altered and how it defines family violence more, and it's more broad-based definition and what the courts must do. And the court says, yes, courts must consider family violence and its impact on the ability and willingness of anyone engaged in family violence to care for and meet the needs of children. Now, those of us who've lived under the Family Law Act for a number of years know that that's there, but it's really good to hear it from the Supreme Court of Canada because we can use that, not just in relocation cases, but in all cases around parenting in courts, in provincial court and Supreme Court here. So again, just reaffirming that family violence is an important factor to consider in mobility cases. And so that was on the family violence. Like that was a breath of fresh air to hear the Supreme Court take such a stance on family violence. And of course, you know, we have Justice Sheila Martin on the court now, and she's been very active as a feminist with Leaf for many, many years. And I'm sure a lot of that's her influence. The court also then acknowledged the importance of considering a parent's need for emotional support. Usually it's focused on finances, right? You know, or mostly it's because somebody's shacked up or getting married or something, right? That's kind of often the ground of why the court's like, okay, that's a good reason to move. But emotional support hasn't been as strongly acknowledged. And so this is a great, again, outcome for women. And here the mother's needs for emotional support was relevant because she had gone to Kelowna to be with the father, but her family was in Telkwa. And so if the move would improve her emotional and psychological state, then that enriches her ability to parent and create a safe environment and positive environment for the children. So the court recognizes, this is lovely, courts have frequently recognized that a child's best interests are furthered by well-functioning and happy parent. Which courts are they talking? Where are these cases of these courts talking about all this? I want to know, but I like it. I'll take it. Anyway, so again, it's like that the emotional support for the mother doesn't just benefit the mother, but also would provide benefits for housing support, childcare, better employment, and opportunities to advance their education, which of course then trickles down to the children and provides better emotional and psychological well-being for the children. So again, here, it all has a direct and indirect bearing on the best interests of kids. So, wow. Anyway, so in addition, of course, being around family and new location can enhance the parents' ability to care for their children, particularly extended families, you know, is very important for not only the parent, but also for the children, and sometimes in terms of navigating their new life. And finally, the Supreme Court of Canada talked about how difficult it is to disentangle the interests of a parent from the interests of the child, and that the reality that the nurture of children is inextricably intertwined with the well-being of the nurturing parent is far from novel. Is it really? Anyway, so, and a child's welfare is in tandem as long as when a parent's financial, social, emotional circumstances improve, so does a child's welfare. And Justice Saunders found that. So it was a really good decision in determining, in putting it out there and really laying a good groundwork for us as activists and advocates to use in support of our clients, not just, again, in the relocation cases, but certainly in all kinds of cases involving parenting, and probably even child support too. And I'll get to some cases where family violence comes into play in division of property and also support issues. But there have been several cases in British Columbia that have applied Barron-Dret, and I just want to refer to one of them. This is a case of Master Bilowich, KHD and OOM, and he cited the Barron-Dret case at length and granted the mother permission to relocate to Florida with the children on an interim application. So from Surrey to Florida on an interim application, not a trial. And even so, the Master Bilowich said that the mother would receive support from her family there and also have some distance from the father. And the interesting thing in this case, of course, is that Master Bilowich acknowledged that there were some conflicts in the evidence that the master couldn't resolve, but felt there was could make some sufficient findings of fact about the history of family violence and ongoing family violence, particularly ongoing harassment of the mother and people associated with her, which would adversely affect the children. So the master didn't need a really high standard of proof of the family violence, but had enough that could make the findings of fact that family violence was a factor, and probably an overriding factor that warranted the mother being able to go to Florida with the kids. These are some of the family violence that was perpetrated by the father: a complaint about the children's counselor to their governing body, which interfered with the counseling, and repeated complaints to the police and other third parties about the mother's partner, which led to the children being interviewed by authorities. Now, it would, sometimes those grounds would, I was thinking about those as whether or not they would raise some concerns for me if that was, I don't think that the extent of it, but I presume it wasn't quite clear all the family violence that was involved, but because, certainly many women can get caught in this when they have to call the police or call the MCFD. And I wouldn't want this to be turned back around on women who do so to be protective and be found to be harassing, and therefore being having committed family violence, which would then lead to a court to make certain decisions on parenting or relocation based on those sorts of things. So, but I believe there was much more than that in this case. Anyway, so that's it for that case. I wanted to move to something. It's like unrelated. I was like, how did this slide get here? I was trying to I always try to do a flow, but I don't know, somehow this fell in here. Interim sale of property. And it's not sort of new law. I just thought it's nice when sometimes you get a case where it sort of states the law. And so you have some reference to, if you've got to deal with an interim sale of property, here's a case you can go to that's quite recent. So the claimant had sought, in order to sell the family residence, was a modular home. She was no longer living there, but the home was occupied by the respondent when he was in town working. So he wasn't always there. The matter came before Master Keathley, and he described the claimant's rationale as an attempt to expedite the settlement of the case, and also provide her with an opportunity to obtain an order for the payment from the proceeds of sale to assist her in funding her legal fees. That's, the interim distribution of assets under Section 89 of the Family Law Act. So those, he understood, were the reasons why the wife wanted to sell the modular home. So the test here is twofold. What is the sale necessary? And if the sale is not necessary, whether it's expedient. And Master Keathley defines expedient as advantageous to both parties. Not just Master Keathley, many authorities, he says, that's how advantageous to both parties. So it's not just if it benefits one person. It has to benefit essentially both people. So in this case, Master Keithley dismissed the application for the sale of the modular home and finding, first of all, that the sale was not necessary. The mortgage wasn't in default. The property was not wasting. And there was no suggestion that the values of property would deteriorate significantly if steps were not taken to market it immediately. Now, as you know, recently, I guess in the last 6 months or so plus, housing prices have kind of dropped. Mortgages are skyrocketing. And so people are finding themselves in much more dire situations. We don't know yet, because it's kind of new for us that this has happened. I mean, we've had a trajectory of upward climb in our market values in most places. I should say that in a lot of places in the province, probably not. I apologize. I'm being very Vancouver centric. And but of course, our mortgage rates have sort of been relatively stable. So the question would would it be sufficient to say, I presume it's obviously anytime if the property will go into foreclosure, that it would warrant a sale, that you could justify a sale. Would it be sufficient if one party wouldn't renew the mortgage, and so the only way to renew the mortgage would be to get a short-term mortgage with a higher interest rate? That probably would justify a sale. What do you do if you're the party who would like to keep the property and this is happening? And the other side is not cooperating. So there's just sort of different circumstances in our world right now that may lend to a finding that these sales are more necessary than not, unfortunately. The other side was, of course, whether or not it's expedient, that is advantageous to both parties, and Master Keithley said the sale was not that. So he looked at both sides to make that determination. On the claimant side, the claimant had wanted to be able to access some of the funds in order to pay legal fees. But Master Keithley noted that, well, it's might get some monies, but there's no guarantee that the claimant would succeed in her application for an interim distribution. One thing Master Keithley noted was that the parties really didn't have a lot of assets. So if there's a distribution out of that, it could actually compromise the respondent's subsequent claims to division of property or compensation, for example. And then on the respondent's side, in terms of why it wasn't advantageous for him, that the modular home had provided him a place to live, and he had said that he wanted to buy out the claimant's interest in the home. And in fact, in his affidavit, he set out some steps of how he would do so. So on that basis, Master Keithley found that it wasn't not necessary and it wasn't expedient, and dismissed the claim by the claimant to sell the house. So this one is interesting. I call it property debt division after death. So it's actually an estate claim, and you go, oh, Weaver estate. It's not. It is a family law claim. But this is a case from the BC Court of Appeal that's important for us to know, because sometimes our clients say, why do I need a divorce? And you'll say, this is why. So in this case, the appellant, former husband, sought to overturn an order dismissing his application to strike a notice of family claim that was filed by the administrator of the estate of his former spouse. Now, the parties have been separated for over 15 years before his former spouse died. But as you know, under the Family Law Act, separation triggers an undivided half interest in family property and equal responsibility for family debt. Right? So unlike the old regime under the Family Relations Act, where you needed a triggering mechanism, it's automatic at time of separation. And the parties had significant property, it seemed. There was real property in BC, Washington State, and Hawaii that were still held jointly by the parties, even though they'd been separated for so long. So, and the former spouse, she had taken no action to enforce her interest in the family property before she died. But the parties never got divorced. So that meant what? The time limit for bringing a claim for the division of property or debt had not expired, because under Section 198 of the Family Law Act, the limitation period is 2 years from the date of the order for divorce. right? So as long as you're still married, or it's not past 2 years post-divorce, there's still an opening where a party can bring a claim for the division of property. Now, you know, this doesn't apply to people who are common law. It's just 2 years from the date of separation. But so I always say to my clients, oh yeah, you don't need to get divorced. You know, what happens, of course, is, as you know, when you separate, the person doesn't get to claim under your will, but it doesn't change this, is that there could be a claim. And so sometimes you tell you want a divorce so that you never have to deal with this, or your heirs don't have to deal with this ever again. That's a good reason now. I was trying to think, what's the reason to divorce? They're like, oh, who cares? A piece of paper. This is a good reason to divorce. Anyway, so the Court of Appeal dismissed the appeal and said that on a reading of the relevant statutory provisions, and that's in the Family Law Act, the Supreme Court Family Rules, and the Wills and Estates Succession Act, looking at it as a whole, it's clear that in BC, an administrator of an estate of a separated and deceased spouse may commence a claim for division of family property and family debt after the spouse's death. So in Section 150 of WESA, it states that a personal representative of a deceased person may commence or continue a proceeding the deceased person could have commenced or continued. That's the could have commenced, right? So at any time, the ex-spouse could have commenced a claim for division of property because they were not divorced plus 2 years. So that, and it's similar sort of statements in the Supreme Court Family Rules around who can be as litigation guardians, who can bring the claims. So the Court of Appeal held that the property interest underlying the cause of action crystallized on separation and did not abate, essentially die on death. And there was some interesting discussion in the case about, like, essentially the unfairness. If a deceased spouse couldn't bring a claim against the living spouse because the spouse was no longer a spouse because they were deceased, but the living spouse could always bring a claim against the deceased spouse's estate. So that created this unfairness, and that the Court of Appeal noted that as well. So it's a case probably that doesn't come up a lot for us, but it sometimes does. I sadly had a client who recently passed, and so now it is her essentially executor who would have to become litigation guardian and continue with the litigation on her behalf. So it's not that it doesn't happen. We probably don't see it too much, fortunately, but it is something to be mindful of. And this is a good case that really sets it out how it does work. And a fun thing about divorce, you know, we never get to talk about divorce much. You know, divorce is generally, you know, simple, right? Separated a year, you know. Anyway, but this case, they met all the sort of, there were no bars to the divorce in that there weren't, they've been separated over a year. There was no collusion, and there was no children of the marriage we had to deal with the support. But the trial judge in this case exercised discretion after finding that granting a divorce would prejudice the respondent wife. The respondent wife lived in India. The husband was here. And the court does retain a discretion if there is risk that would prejudice the case of a party, particularly in the collateral issues. It's usually around the property stuff. And I've had argued cases where in some countries, if the parties are divorced, then the wife essentially loses all ability to access properties in that country, essentially, to make those claims. So that's one reason why I have previously argued against the divorce at this time, at a particular time. Anyway, the Court of Appeal, though, said that, yes, there is discretion to do that, but it's not just, you have to look more at just, is there some risk? There has to be substantial risk, and there has to be, we'll get to it, actual risk. So that's the key, is actual risk. What the trial judge did was look at potential risk of prejudice to the respondent wife in granting divorce. And these were sort of the grounds in which the trial judge made that decision. that the wife lived in India, and because of the pandemic, she had difficulty instructing counsel. That the husband's position was that she wasn't entitled to property or spousal support, and that there was concern about the husband's financial disclosure, and the husband was unavailable for an examination for discovery. So that, to the trial judge, was sufficient risk of prejudice to deny granting the divorce. The Court of Appeal said that the trial judge applied the incorrect legal test. And I said, it's not for the applicant to prove that, the reasons for getting a divorce outweigh the risk of prejudice. It's really the party opposing the divorce has to establish that the granting of the divorce order would give rise to, again, actual prejudice or a reasonable likelihood of prejudice that arises from their loss of status as a spouse. So the Court of Appeal didn't find that the facts in this case rose to a level of actual prejudice or reasonable likelihood of prejudice. And so it overturned the decision and that a divorce can be granted. And also the Court of Appeal held that the trial judge sort of erred in principle by declining to grant the divorce to incentivize the appellant to resolve corollary issues. So it's kind of like the little hammer. You want your divorce, then come to the table, give your disclosure, go to your discovery, and, then come to court and get this all settled. So the Court of Appeal said that wasn't an appropriate ground to not grant the divorce. Something on spousal support. This is, there's a couple cases here that just talk about we always think about this, the spousal support advisory guidelines. These are cases about how important it is to follow them. And in this case, OC and MVSG, the trial judge had ordered an amount of spousal support that was more than double the high end of the applicable range under the SAGs, the divorce mate calculations, right? So the Court of Appeal held it was an error for the judge to do so and reduce the monthly support to $720, which I don't recall. It's probably the mid-range of the SAGs, what would come out through the SAGs. So the court noticed that a judge is not obliged to use the SAGs when determining the spousal report. However, if there's to be an award that's substantially lower or higher than the applicable range, the court must justify why they are going higher or lower. It's not just, I feel like it. There's got to be some reasons for that, what they call an anomaly. And it has to be based on what the Court of Appeal says, exceptional circumstances, right? Not just, you're a bad guy, I'm giving her more cash. I mean, I'd like that to be the case. That'd be good. So in this case, the Court of Appeal found there was just no reason, there's no explanation given by the court to have strayed outside the applicable range. And the judge also used the wrong divorce mate calculation tables. And so that's what led to partly some of the incorrect number in the end. And which was weird, is that the Courts of Appeal said a mistake in the use of the application of the divorce mate calculation can form the basis of correction on appeal. And in fact, the appellant had actually gone back to the trial judge and said, hey, you used the wrong divorce mate calculations. So can you just essentially fix it? And the trial judge declined to do so. And that's what then led to the appellant proceeding with the appeal. So this is, again, just a reiteration that the spousal support guidelines or the divorce mate calculations that arise from that are important to consider, and you kind of need to stick in the range unless you can figure out some exceptional circumstances to go outside of that. The next, I want to talk a bit about lump sum spousal support. This is really unusual, and I don't know if it would really happen again, because it just seems, I don't know how a trial judge, I forgot to check who the trial judge was, so I shouldn't say anything. They might be somebody I really like. But anyway, the parties were together 28 years, and I like this. The husband was a real estate agent, gambled, and dabbled in questionable income generating activities. But throughout the relationship, he was the primary earner, and the wife was responsible for the household and raising the kids. So no question, the wife was found to be entitled to a compensatory spousal support based on her role as a primary caregiver of the kids. So, but moving forward, the trial judge awards the wife a lump sum of $50,000, despite the fact that her post-separation income was in fact higher than the husband's income. So the trial judge had imputed some income to the husband, but it was a modest amount, which still didn't take him above the wife's income. And the judge also declined to impute $180,000 to the husband, which is what the wife was seeking. And so in that case, if that imputation was granted, the husband's income would be double the wife's income. Well, that didn't happen. Anyway, despite all that, the judge says, I'll give you 50 grand in a lump sum. The Court of Appeal said, no, you cannot do that. You cannot do that. You need to look at again, back to the SAGs. You need to look at those, and because the SAGs are part of the process in quantifying spousal support. And that, again, only in exceptional circumstances can a judge sort of go outside of the boundaries of the divorce-mate calculation of the SAGs, right? And the court also said that the trial judge didn't refer to the SAGs or identify any justification of why a lump sum amount was warranted. And there were no unmet needs or special conditions or any circumstances affecting either party. So again, the court is saying, these are the things you need to show to the court if you want to go outside of the SAGs. SAGs, you can do a lump sum amount as well. And of course, there's no exceptional circumstances that could support a spousal support award to a higher earning former spouse. And that's generally the case. It's essentially, as you know, you can have a compensatory claim, you can have a needs-based claim or so forth. But if your ex, it's similar to child support, if your ex earns nothing, you're getting nothing. And that's the situation here, is that in fact, an entitlement is one thing, but then you go to quantum, and if the amount that the husband's earning is close to what the wife is earning, essentially you're going to get a zero coming out of the SAGs. So I don't think it was an interesting one, because a lot of times we do ask for lump sums, and you kind of think about it. You have to then, if you want a lump sum, you have to sort of do it more like a reapportionment of assets. If the incomes, you still have to, you can't just say, oh, he's an ass, I want lump sum spousal support. You need to be able to justify that. So, yes, sir?
Agnes, I was wondering, what about if he had questionable income activities? Is it possible that a big chunk of his income actually was hidden, and that's really what they were going for?
I'm sure that's what the wife was going for, but the trial judge didn't go there, right? The trial judge didn't impute income, or didn't, I think, make some comments about, I think your income should be a lot higher. I think
it's common, that assets and income are hidden, and
absolutely
get all twisted around and backfire on the other.
So it would just appear in this case the wife wasn't able to prove that, made some comments about he's a gambler, and apparently he was a bad gambler then. I don't know. But she wasn't able to convince the judge to impute his income at $180,000. Obviously, if she had, we would probably be able to justify this lump sum spousal, because it would just be about the quantum matches the amount. Right. Yeah. It's as you all know, it's really hard to prove somebody's income when they're hiding things, right? And well, not always, but it is sometimes quite difficult. And even when you can show, like, look at their expenses versus their, income, it doesn't always get you there, right? That's not enough. So, but it is it's important to sort of, imputing income is quite the challenge. But I think it's, in many of our cases, that's what we're trying to do. How many of us have clients who, their exes are, I have my own business and I earn $20,000 a year, or, and that can't be true. But then how far do you take them, right? They say, essentially, I'll give you minimum wage, which is still only like 40,000, which just doesn't really help the mom was trying to raise several kids on her own, essentially. So, yeah, but it's an important one that I don't know if I haven't seen anything sort of more recent about really good cases that say, here's the, magic wand that will get you to imputation of income. Yeah. Thanks, Sarah, for that question. Look, this one doesn't get you there, just so you know. I put this in because it was actually the husband, Mr. Livingston, who is trying to take the wife's new partner, his income, and impute it to the mother and use that for child support purposes. This is that whole household income idea. And why can't is it the household income that is imported into what is the income for the purpose of child support or spousal support for that matter? And as you know, when the Family Law Act came, it changed the provision around child support and step parents, because there was a little spot where you could actually go after a step parent for child support when they weren't separated from the parent of the child. And that got all fixed in the Family Law Act, where now it's the biological parents who have the primary responsibility for child support, and then the step parent comes next. But in the Family Law Act, you can't go after a step parent for child support unless that step parent has actually been separated from, one of the parents, right? So Chief Justice Hinkson said that the claimant was trying to sort of indirectly do what he couldn't do directly, which was basically to actually have the step parent be that income just be as is. This is your income, this is the ex-spouse's income, and we combine it. But sort of, well, I'm just going to impute the fact that the income to the ex-spouse based on what the step parent was earning. And Justice Hinkson says, doesn't work like that. So I don't know how many people would try this, but they did. But they did. Anyway, there's only sort of 3 scenarios where the income of a party spouse comes into play. It's really when there's a hardship claim, because you deal with household income then. When the parties are in a shared parenting regime, because most people just do the straight set off, but Section 9C talks about the condition, needs and means of the children and the parties, right? So that's where, if you're in a shared parenting, but you don't need to work because your new spouse is earning like $1 million, and so you can just stay home with the kids. The court will look at that in terms of this is why. I mean, that's also ground to impute income as well. If you're a trust fund baby and you don't have to work, again, same thing. And then when a party's income is over $150,000, Section 4 of the Federal Child Support Guidelines, again, the court can consider, again, the conditions, needs, and means of the parties in determining what's the appropriate amount of child support to be paid. So that's what I say here, and the financial ability of each one. Anyway, so this was just it was just a fun case that I was like, oh, somebody tried to go after the step parent. Interesting. Anyway, it didn't work. So this is a case around calculating income from 2 sources. So the first is, and this probably comes up for many of us, is around withdrawal RSPs, right? More and more when we have clients who are in financial distress, they can't hang on to the RSPs till, when they should be able to use them at retirement. They need to cash them out. So the question becomes, are RSPs your income? Now, these are RSPs that have been divided at some point during the parties' breakup, or new RSPs. And certainly, the argument is similar to pensions, where it's like, is it not a double counting if, we've divided our RSPs and now you're counting it as your income? In general, the rule is that your RSP withdrawals will be included as your income, particularly if people are a bit further away from their separation. But in this case, Justice Edelman held that the mother's withdrawal RSPs were not, I'm jumping ahead of myself. Sorry, I'll jump to that. These are 2 questions, but the first question is the mother's RSP withdrawals they could be included in her income, but it would be unfair to do so in this case because the reason for the withdrawals were that the mother needed to buy a home and a vehicle because after they separated, the father retained the family home, and so she had no home. So he felt, Justice Edelman felt that was an appropriate use of the RSPs that weren't to be included in the income of the mother. Now, if the mother had just cashed RSPs to go on a trip or to probably even feed herself, it would probably be included as income. It takes a little while after separation. I think several years often pass before that happens, because otherwise it seems way too connected to the division of the asset. So that's the side of the RSPs. And I apologize because I haven't really looked at all the cases, so I'm not sure how many go the way I've described it and how many are going the way that Justice Edelman's describing it. He doesn't really cite all the cases. So the ones I've seen are generally that it will be included in income, unless you can, again, show that it's used for a particular, oftentimes the children's purposes. And then the other side of the issue was whether or not the husband who was running his own business was claiming a capital depreciation and whether that was legitimate for the purpose of essentially reducing his income for child support. And Justice Edelman found in this case it wasn't reasonable because essentially he had a company that was owned by him and his parents and the mother. And then after separation, he got a grader and he started his own business. So then because his dad gave him a grader, that allowed him to claim it on his income tax return and the depreciation of it, which is not untoward it's not illegal under the Income Tax Act. But Justice Edelman said, hey, essentially, there's no reason why your income should be lower, but for the fact that you are just claiming depreciation, because essentially you're doing the exact same thing that you used to do in a different business with your parents. And so your income should be essentially the same. So Justice Edelman didn't allow that deduction. So the father could not reduce his income. So the mother's income didn't get to go up, it stayed down, and the father's income did not get to go down, it stayed up. So those are two circumstances where recent case where a court sort of looked at, well, what goes into income. So this is an interesting line of cases around school. Some people say that the court doesn't have jurisdiction to essentially decide the school, that the court has to basically just allocate parental responsibility to one person over education. That's how they have to do it. And I've heard that said many times, even by their lawyers, and they rely on a particular Court of Appeal case, which I'll refer to. But in this case, the Court of Appeal sort of affirmed that case in GR, but also sort of clarified how it worked. So this is a decision called Rida and Birch. And so the question is, again, as I said, can the court make an order that a child attend a specific school, or can the court only allocate decision-making authority or parental responsibility over education of one parent? And that allows that parent to choose a specific school. Because you will see a lot of times, we think, oh, that's what you have to do. You have to basically it's same with healthcare, just so you know, it's any decision. Like, can the court make specific decisions in the best interest of the child, or can the court only allocate the responsibility to a parent, one parent or the other? And the court's very clear. So here, the father had sought leave to appeal an order of the chambers judge, who gave a direction as to whether where the son would go to attend secondary school. And the father again argued that the court didn't have that power to do so and should just give him the parental responsibility to make that decision. The Court of Appeal dismissed the father's application for leave, but also then weighed in on the merits of the case and on the issue, and clarified the impact of the Court of Appeal's earlier decision from a few years ago, NRG, on decisions and orders about parental responsibilities and the interplay of Section 45, which are orders respecting parenting arrangements, and this key one, Section 49, referral questions to the court. Now, most of you are probably familiar with Section 49 because it often says that, you know, for parenting decisions, the parties will consult with each other and use their best efforts to try to come to an agreement. If the parties cannot come to the agreement, then Sonia can make the decision, subject to Agnes retaining the right under Section 49 of the Family Law Act to essentially say to the court, Sonia's decision was not in the best interest of the child, and therefore you must overturn it. So that's Section 49 allows the court to make these what we call directions around specific parenting decisions. And so that is what the court here is stressing, is that remains within the power of the court to do. So the Court of Appeal says, yes, like in NRG we said, that's clearly there's going to be situations where the court will have to be called upon to resolve specific disputes, right? Not just allocating authority, but specific disputes. You know, the big one, and I get to it, is COVID vaccines, right? That's a huge one. So school is another one. Counseling is often a big one as well. So the Court of Appeal says, look, our previous decision in NRG said, hey, the courts really shouldn't take over the entire parenting regime. So shouldn't really be dictating every single decision. But that decision doesn't say the court can never make decisions about a specific aspect in the child's life, including education. Nor does it say that a judge can't give some directions on matters that are typically parental responsibilities when the guardians seek guidance under Section 49, as they did here. So the guardians are supposed to come to make a decisions, but when they can't reach that, well, the court steps in and on an ad hoc basis at the bequest of guardians will make a decision. So it would be a specific school. It wouldn't be, the court wouldn't necessarily dictate, okay, for kindergarten, Sarah's going to this school, and then when she gets to high school, she has to go to this school, and she's going to go to UBC. The court can't make those kinds of orders, but can deal with it as they come up, right? So that's sort of the restricted power of the court, but the court can make those decisions, is what, in this case, the Court of Appeal stressed. So, and that's important because a lot of times parents will think, they have the power to make these particular school decisions, and I can't have it. I don't have any ability to challenge that, or, how can we get the court to make a decision? You have to stress to the court, you can make that decision, this one little decision, this one discrete decision. Anyway, and they said, if you look at the language of the legislation and it's a scheme, it fits in like that. So here, if the trial judge had allocated parental responsibility for the education to the mother, meaning that the mother lived in Vernon and the child would be going to school, it would also affect other children in the family, because that would give the mother the authority over the whole the caboodle. And just so you know, the father, who was living in Kelowna, he wanted the son to go to the Catholic school in Kelowna. And I should say, I went to that Catholic school. Different location, but it was in Kelowna. I was like, oh, I know where you're sending that kid. Don't do it. I was kidding. So yes, so the court here on the application for the judge ordered what they call an education direction. So the same they'll do for healthcare directions or passport directions. So anyway, another case around, this is an interest choice of school. And I put this case in White and Schultz because it also triggers sort of a charter discussion, Section 15, because the father has disabilities and he has some challenges in mobility and bringing the child to school. So the parties lived about 15 kilometers from each other. It's a 9-year-old child, and the child was attending school near the mother's home. And they had equal parenting time. And this determination of where the school would be for the child had already been determined. The father said due to his disability, due to his disability, the father did not drive. And he said he couldn't use public transportation. That using public transportation posed a health risk to him, particularly due to COVID-19 and his disability. And so he said commuting to school by public transportation was not in the child's best interest and was discriminatory against him under the charter, Section 15 of the Charter, equality rights, or probably Section 7 as well, security of the person. The mother was already doing some of the driving to school, so that the father did basically one trip a week, one trip a day, and then the mother did the rest of the driving. So that was the quote unquote accommodation. Anyway, the chambers judge didn't accept the father's position and said the health risks were within reasonably tolerable levels given public health protocols and vaccination. So there's just this blanket acceptance that we've got everything right around particularly COVID-19. And the judge also said that it was in the child's best interest to go to school close to the mother's home because the mother could easily attend the school in an emergency since she drove and had a car, and that the child's half-brother was also going to that school soon, and the child benefited from stability in social and educational relationships. So that's all that true. So I'm not sure what the father would have to prove or show to say it wasn't a reasonable tolerable levels to make me take a bus with the child in this era of the COVID pandemic. But unless I guess at the time Bonnie Henry said, don't take your child on the bus if then it's all good. So that's been a challenge for lots of people who've had health issues in this pandemic, as everyone knows. And it's still not over. Sometimes we think it is. So again, the Court of Appeal dismissed the father's appeal and saying there was no meaningful evidence about the health risks posed to the father because the only evidence he had was to whom it is may concern letter. And the judge had recognized the heightened risk of the father, but properly took judicial notice of public health protocols and the availability of vaccines. So again, as I said, there's no discussion of what would be unreasonable risk level. And the reality is, the to whom it may concern, I don't think you would find a lot of doctors who would be able at that time to weigh in on what the actual risk was, severe or not, or who would be willing to do that. So the father was in probably an untenable position in terms of trying to prove his case to support his position. And then just regarding the charter argument, disability, of course, charter arguments can come into family law matters. But the court found that the chambers judge didn't ignore the father's disability. If the chambers judge had, that would have been error in law. But the Court of Appeal found the father's disability was considered, respected, and accommodated, not for its own sake, but in relation to the child's best interest and the father's ability to continue to participate in the child's life and meet her needs. I don't know. Anyway, I think part of that was just that the mother was, again, agreeable to do some of the driving so that the father wasn't on the bus all the time. But otherwise, I didn't see a lot of accommodation that was being proposed, but there you have it. Okay, let's talk about some division of family property, because I always seem to not get to this stuff. And it seems to be important for most folks. But anyway, this appeal, Hannon and Hobson, addressed the application of Section 95, so the unequal division of family property, of family debt. And the parties were in a marriage-like relationship for 14 years. They first got married and they were born and raised in the UK, and then they later came to BC. And then during the relationship, the appellant had received a settlement for a medical malpractice claim regarding, and it damaged his vision, which was subsequently corrected. And so those funds were deposited into joint accounts and then were used over time for various expenses and to purchase a house. So the husband tried to get an unequal division of the family property given the source of the monies, which was basically his personal injury settlement, but the judge declined to do so. The husband appealed, basically saying that the trial judge erred in her analysis under 95-2, and also in how she treated the settlement funds, and also how she failed to consider that there was significant unfairness arising from the different legal regimes between England and BC regarding property division of unmarried spouses. So this is like a choice of law. Basically, the father saying, the husband was saying, you should deal with, if we were in England, this is how this would work. You can guess how the Court of Appeal decided on that one. Anyway, the appeal was dismissed. In terms of the findings of fact, the Court of Appeal found that the appellant showed no error in the trial judge's finding of the application of the law in exercising her discretion in not granting an unequal division of the property. So the settlement funds that the the trial judge correctly recognized that she should consider the source, but the origins as excluded property did not render equal division unfair, because the trial judge stood back and looked at an overall assessment of the parties' financial contributions over the years in the context of finding that they operated as a single financial unit during the relationship. Now, remember when we started all this Family Law Act and the property regime, it's so clear. It's like, oh, excluded. This is so excluded, right? I can get this back. My inheritance, the money I had before we got together, or here, the settlement funds. The courts of appeal have been really chipping away at that in terms of looking at, like, if you are really mingling your excluded property into, your joint ventures, essentially, we're getting back to that notions under the Family Relations Act, you're losing that. You're losing your exclusions. And I'll take you to another case that shows that. So it's sort of this intention. Did and 14 years before you had this legislation, of course, people are doing different things. Then the legislative regime changes, right? Oh, I can get my excluded property back. Well, they're now like, well, you may not be able to get it back. So in this case, the court, it wasn't just, simple, yeah, this is a category of excluded property. Yes. But here, given how the parties have essentially managed their financial lives and used the monies, then the exclusion is essentially gone. And so therefore, and on that basis, since it's gone, there's no discussion of unequal division anymore. So, and then in terms of whether or not the trial judge had erred in not applying essentially English law, the Court of Appeals said, hey, the parties, there was no evidence that they had any legitimate reasonable expectation or were planning to deal with their property or support or anything under a different regime. Because that's when you would probably say, if somebody came in and said, I'd like to have the law of England applied, then you say, well, then you should have an agreement that says the law of England will apply to all our property here. Not saying the courts here would find that to uphold that such agreement, but that's what you would have to do, at least to express this is what our intention is. So the Court of Appeal found there was no intention of that and poo-pooed that ground of appeal as well. This is what I was talking about, the loss of excluded property. This is a case called Haley and Haley, Justice Horseman, who is now in the Court of Appeal. The parties had a house in Prince George. And at one time, it was the claimant wife's excluded property because she had it before that her relationship with the respondent. So the trial judge says, hey, now it's in joint. So the real question is, does the evidence support an intention by the claimant to retain the Prince George house as excluded property rather than gifting it to the respondent, or vice versa? Does the presumption of advancement apply? The trial judge doesn't deal with the presumption of advancement, and I will not as well. But now it's like, wow, it's about the intention of what were you intending to do. So it may start as excluded property, but if you convert that into some sort of joint thing for whatever reason, it's important to know what your intention is, right? So same as like if somebody gives you money, is it a gift or is it a loan, right? The intention now matters so much more. So in Reasons for Judgment, Justice Horseman looked at, she found that the evidence supported that the claimant intended to gift her interest or half interest to the Prince George house to the respondent at the time that the parties got married. And so therefore, this was the evidence. The house was a family residence from the time they were married. The claimant did not testify that she intended to maintain her interest in the Prince George property rather than gift it to the respondent. And then such an intention isn't reflected anywhere in the evidence. So you have to show it's not as much you have to show you did not have an intention to gift it now. It's not about is the intention to gift, but I did not have the intention, and you have to prove it. And so really the only way to prove it is either one, you can have an agreement that says, I'm putting you in joint tenancy for the purpose of estate planning. If I die, of course it's yours. But if you, have an affair and run off somewhere, then you're out. So you need an agreement that says that if you put something in joint names. Yes, or at some point you would have had to note at the time, have somewhere documented somehow that at the time you were putting something in joint names. This is the only reason I'm doing it. It's for the purpose of, if I die, estate planning, not for the purpose of if we separate, that the intention is that person gets half the interest. So, so that was one of the things that, the onus goes back on the person who is claiming on the person who's claiming the exclusion to show that they didn't give away part of their excluded property. And then, ta-da, when they sold the Prince Rupert house and moved to Prince George house, and moved to Red Deer, they used the proceeds and purchased a house in joint names. So clearly there was no intention of doing that. But there's a whole part of the Family Law Act that talks about tracing, right? You can trace things. Well, anyway, apparently you can't trace anymore if you put things in your spouse's name. So it's really, really putting a lot of limits around what is now going to be excluded property. There's a number of cases that are like that. So again, as I said, this is a case where, yes, the exclusion was lost. Some more. Here's some more evidence, sorry. And they purchased more properties and they were all in the, in joint names. And then there was no evidence the claimant took any steps over the course of a 24-year marriage to maintain the excluded property despite the growing financial interdependence of the parties. So again, same things, like she didn't have an agreement, she didn't keep it in her own name, and so forth. So the evidence to the court, Justice Horstman, was you clearly meant that to be joint and together, and goodbye exclusion. Now, I presume that would apply for debt as well. I don't know. I mean, if it's in joint names, obviously that the person can't claim that, well, that's excluded debt. I wonder if that, I haven't seen the cases around that, whether exclude, debt, that if you put a thing in joint names, the property, I can't see how it's fair if it says, well, and then the mortgage that went with it, you have to keep it because that was excluded. And I suppose if you put it in joint, you have to put the mortgage in joint names too. Okay. Maybe there's, I don't know, something there on debts. Anyway, let's move quickly through reapportionment.
Agnes, there's a question.
Oh, where's the question? Hi. Who's it?
I've withdrawn.
There you go.
I've withdrawn it. Sorry.
What?
Yeah.
Okay. Right. There we go. Just while I'm on mic, do we need a short break? Or
Do you need a break?
I can't see what everybody's going to say. No?
Okay.
Okay, good.
Right. Well, let's talk about the decision of Justice Whatcom, Ardith Whatcom. Many of you may know. Wrapping away, it's around you. Yeah. Anyway, it's called Paseska and Paseska, and this is a reapportionment case. So the respondent husband sought an unequal division of the former family home on the basis that he had paid the house expenses, including the mortgage, since separation. Justice Whatcom dismissed the application, as on the other side, of course, the claimant had to pay for housing herself for the children, and it was largely due to family violence by the respondent that the claimant had to vacate the family home. And in fact, despite the fact that MCFD was involved and basically told the mother, you cannot have this guy in your house around your kids, or what are they going to do? We're going to come apprehend your kids. What does the husband do? He moves back into the basement suite of the house and refuses to move, which is why the mother finally has to just move out of the house with the children for fear of their own safety, and also fear of apprehension by MCFD. So in this case, Justice Whatcom didn't allow for a reapportionment and just ordered the family home to be sold because. My friend Miguel Huberman, who some of you may know, she's with Access Pro Bono now. And I do actually should acknowledge that a lot of the case summaries she had prepared for Access Pro Bono purposes and stuff. So I was able to draw on some of those, which were very helpful in preparing this, because I really trust her smarts about things. But anyway, she talked about another case around reapportionment that had to do with family violence again. So in this case, Justice Kirchner, it's 2021, so it's it's outside of my 2022 timeframe, but Justice Kirchner reapportioned property in favor the wife was a survivor of family violence, in part because of the impact of the violence. And he cited another case from the BC Supreme Court called Chang and Chang, which seems to provide some authority to reapportion family assets in circumstances where there have been bullying conduct on the part of one spouses. Anyway, but in that case, there were a number of other factors that were at play that led to a 75-25 split. And some of those factors weren't present in this case, Salmon and Astephan. However, Justice Kirchner did find that the abuse that the respondent faced at the hands of the claimant was a factor that the judge could consider because it did have a connection to the economic characteristics of the spousal relationship. So the parties had a restaurant and the wife worked in the restaurant, but because of the claimant's conduct, the husband's conduct, she couldn't devote herself to working in the business in a manner that she would like and intended to in the final years of the relationship. So that affected her economic well-being and stability. The judge accepted that the wife's evidence in that regard about the impact on her ability to continue working in the restaurant, and said that were it not for the claimant's violent, abusive, and degrading conduct towards the respondent, it was more likely than not that the restaurant would have been more successful in those years because the wife would have been able to work in the restaurant. He couldn't quantify the impact, but he said he was going to take it into account in determining whether or not there should be an equal division of assets or a reapportionment. And in the end, Justice Kirchner reapportioned the family home in favor of the respondent. So this is a case that is directly linked to family violence and reapportionment of assets. This is another decision that has to do with property, and this is a case around date evaluation. This is a Court of Appeal decision called Ban and Chrysler, and the trial judge determined it would be significantly unfair to divide certain properties based on their value at trial, and so divided properties based on values at the time of the date of separation. And the appellant husband appealed that. So in the judge's decision in picking the date of separation as the date, and you may know that Section 87 says that the valuation for property debt division is at the date of trial unless the court orders otherwise. So the court can do that, which some say it's like a reapportionment, or the judge can use reapportionment to address those issues. So there is discretion for a judge to do so, but there are certain factors that, anyway, the judge identifies a number of factors for why the judge picked the date of separation, which include the short duration of the marriage, the fact that the respondent, who was the wife, was not the owner of any of the husband's rental properties, the claimant's exclusive efforts to develop, manage, and maintain the rental properties, the considerable growth in the value of the rental properties that occurred primarily after the parties separated, financial advances made by the claimant to the respondent prior to and during their marriage, and the respondent's unilateral setting a trial date 3.5 years after the parties separated. Because you know how well we can control trial dates. Anyway, the Court of Appeal allowed the appeal and said, yay, the judge accurately summarized how the property division regime works, but then relied on factors that just don't fall within those enumerated under Section 95(2). And the court also said they fell outside of Section 95(2)(I), which is sort of the catch-all of other, right? Actually, I just realized I better check that. Pardon me. 95(2), any other factor other than considerations referred to in subsection 3 that may lead to significant unfairness. So not only it didn't fall in any of the listed items, but it also, in that sort of catch-all category, anything else, the Court of Appeal said that many of the things you said are outside of that. And which are the ones that are outside of that? Not surprisingly, the last 4 that were named about owning property, considerable growth, the financial advances given by the husband to the wife, and then the setting down unilaterally of a trial date. So, the Court of Appeal said it wasn't appropriate to rely on those factors in changing the date evaluation. So allowed the appeal in this case. So it seems to be that this, yes, the 95-2I, it's not as broad as maybe some people might want to use it as. And so there must be some, I guess, solid grounding as to why you would use a different date evaluation. And a lot of it is, for example, if somebody is ramping up the debt, right, then often the date of separation would be when you would want the debt to be valued at, not when somebody then takes out an extra 100,000 and then, at trial, look at the lines of credit is worth this amount, right? Or somebody who's wasting away the asset, is in the family home, but is having, parties every weekend and trashing it so that the value goes down. Again, you wouldn't want to use the value at the time of trial if the value had gone down due to that conduct and so forth. So there are reasons to pick the different dates, but the grounds that this judge used were not found to be appropriate by the Court of Appeal. This is a case, this is about agreements and when are they legally binding. And this is a memorandum of understanding. And I like this case only because the parties have participated in the virtual family mediation project, who many of you may know about, that's run through Access Pro Bono. And I try to be involved with it, but I'm not, I haven't been as available, but I'm hoping to be much more involved in it. So if you do have clients that need that, this is my friend Miguel Huberman is coordinating that, so give her a call. Anyway, so there was a memorandum of understanding that came out, and the intent was it was supposed to be converted into a separation agreement and then signed by the parties. So the memorandum of understanding, it's all done virtually, right? So the mediator, Kendall Pollitt, prepares a memorandum of understanding, sends it to the parties. The parties are supposed to get legal advice, and then one party's lawyer was going to draft it, make it into a separation agreement. So the parties actually didn't sign the memorandum of understanding. But so the question was whether or not the memorandum of understanding was a binding agreement, because the parties also didn't end up executing an actual separation agreement. They didn't sign off on it. Now the husband, respondent, was arguing that it was just a tentative. It was subject to him getting further legal advice and then accepting it maybe later on, because he didn't want to essentially to abide by certain terms of the MOU. So Justice Elwood went through the test. It's essentially, is it a contract, right? It's contract law. So would it be clear to an objective, reasonable bystander, informed of the material facts, that the parties intended to make a contract, and whether or not there were the essential terms of a contract that could be determined with reasonable certainty, like you knew what the terms were, what it meant, right? It wasn't conditional on something else. So there has to be an intention to contract. Clearly, they went into mediation. They were intending to come to an agreement. They came up with a MOU. The essential terms must be agreed to by the parties. And the essential terms must be sufficiently certain. So in this case, again, sorry, I repeated that, but essentially it's somebody standing outside, objective bystander, would they consider this to be a contract? And you look at the context around everything, the communications between the parties, the conduct by the parties during, before, and after the agreement was made. And in this case, for example, the husband was following some of the terms of the MOU, but then just didn't like certain other terms, right? And so that was part of the conduct in which the court found that the respondent, in fact, had in his mind that they had come to an agreement. So again, it contained all the essential terms of a final agreement, and it didn't have clauses that would make the agreement subject to either party obtaining legal advice or communicating their acceptance following the agreement. It was a final agreement, And it made reference to this is a settlement reached by the parties. So again, if you're helping clients with drafting agreements and you want to know that that before somebody signs and you get an agreement, that you want certain language in it that it's clear that this is to, when we always say like this is to settle all matters arising from the breakdown of marriage, spousal support, property, blah blah blah, and because you want that certainty, right? You want to not leave holes that may open things up again. So in this case, even though the memorandum of understanding wasn't signed, Justice Elwood found it was legally binding because it met the test of a contract. And again, looked at the parties' conduct and said that the respondent's conduct immediately following the mediation was consistent with having accepted the essential terms of the settlement, and was inconsistent with his only having listened to the terms that still required his acceptance. It's like, oh yeah, I'll get back to you. And just so you know, throughout, the parties had access to legal advice. So it wasn't a situation where there was no legal advice in terms of when they came up with the memorandum of understanding. So the Justice Elwood found it's legally binding. Child support. This one is, I picked a couple on child support that this is one with a disabled adult child. And I use the word child just in terms of the legal definition. It's still a child in marriage, not that the person is child or childlike. The person is over the age of 19. But the father wanted to terminate support for his child who has disabilities. And since the previous order was made around child support, the father was also challenging spousal support as well. The party's child had become an adult and was receiving personal disability benefits, and also was able to have a part-time job. So in preparing a budget, this is the important thing where the child shows that income is higher than the estimated expenses. That said, the child continued to live with the mom in co-op housing for low-income earning families. So part of the child's expenses wouldn't have been a high rent if the child had been living on his own elsewhere from mom. So Justice Burke accepted there had been material change of circumstance in that now the child was 19, receiving some income and working, right? But that the evidence from the mom and the child's physician satisfied Justice Burke that the child required ongoing care and supervision, and that those were provided by the mother, who basically, when she wasn't working, was supporting her child, right? And so Justice Burke then also stated that because the child's work hours may be reduced in the future because of difficulties arising from his disabilities, that it wasn't the time to cancel child support, to terminate child support. What Justice Burke did was did some math, I guess, and looked at and determined sort of an estimated shortfall for the child per month, which was allocated equally between the parents. So it was $500. But although the justice didn't terminate child support, it led to a great reduction of child support, because now the father only had to pay $250, basically the shortfall, half of the shortfall. And for some reason, the justice comments that she did so reluctantly. But essentially, because the child had income, a significant amount of income to cover his expenses, that it was basically the balance was just to cover what would be the shortfall. Now, if the child was still a child of the marriage, just kept the child as a child of the marriage, and if the mother and the child, for example, lost their housing and had to get more housing, and therefore the child's expenses went up, it would certainly be open to the mother and the child to go back to the father and say, you need to up how much child support you pay, because I'm not able to meet the child's not able to meet their needs anymore. So anyway, that's one case of how it often works with an adult child with disabilities. Now, oftentimes the courts will sort of look at how much the child or the parent caring for the child is accessing any kind of government or public supports as well. in terms of determining what amount should be covered by the other parent. So it's something to keep in mind. There was one case, actually, I didn't put it in here. The parties had an agreement that the mom would keep receiving the child tax benefit. It was about $1,300 a month, and the father would always ensure that she never had less than $1,400, right, a month, and that was his quote unquote child support payment. And the court tore that agreement up and said, child tax benefit is not income for the purpose of, first of all, you're the payer, child support. So that was the case where it's like, I think the parties did it on their own probably. And it was just like, nope, that's not how the child support guidelines work. So the father had to pay a lot more. And the mom still got her child tax benefit. Well, they had agreed that the mom could claim, say that the children were in primary care of her, but in fact, they had a shared parenting. And the problem, of course, is if CRA gets whiff of that, the mom could be subject to big, overpayment bill, right? So it's dangerous. I don't advise my clients to get on the bad side of CRA. So another child support case I want to mention is where there's a fractured relationship. The father, in this case, Thompson and Thompson, wanted to terminate child support because the adult child, who was 21, had unilaterally terminated her relationship with him. The child was in university and so would otherwise qualify as a child of the marriage and be eligible for child support. So the question is, did the child wasn't speaking to the father, and there has to be a determination, is it the child's fault, and should therefore child support be terminated? Well, Justice McNaughton said that, termination of a parent-child relationship would rarely justify termination of child support, except in the extreme and egregious circumstances. So the obligation to pay child support, it's like we don't do cash for kids and parenting and child support. We say, I'll give you $10,000 if you let me keep my kids, or, I'll pay you to go away kind of thing. Well, it's sort of the same here. There's an obligation to pay child support, no matter what your relationship with your child is, unless, as they say, it's extreme or egregious. So in cases of alienation, certainly there would be probably a termination of child support. But in this case, Justice McNaughton said those facts aren't present here. And in fact, Justice McNaughton found that it was the father, really, by his conduct and his rigidity, that led to the fractured relationship. And so he didn't get to terminate child support. So that's, it often comes up, as you know, particularly with parents paying child support to kids who are in universities and so forth, where I think you do see a fair number of these cases where a parent will say that, my child basically doesn't speak to me, and therefore I shouldn't have to pay for any child support to this child or support them in their post-secondary education and so forth. And the court steps back and tries to figure out, well, what is the basis for the fractured relationship? And it can be, obviously, if the father has been violent towards the child or mother at some point, that is certainly a reason for the child not to have a lot of contact with this person. But again, then the court says, well, that's on you, Dad. You're an ass. It doesn't absolve you from your obligation to pay. So anyway, so this is a nice sort of, I think, statement of, how to look at what we call fractured relationships. One to look at this is an appointment of a guardian case. This is from Justice Edelman again. The parties had a child, and unfortunately the father was suffering from mental illnesses, and he really couldn't conduct his affairs by himself. And for the court proceeding, he had a litigation guardian. So the father's sister, the paternal aunt, sought to be named as a guardian of the child and sought to share parental responsibilities with the mother. Justice Edelman held that it was in the best interest of the child for the paternal aunt to be granted guardianship, and to increase the parenting time of the child with the father and the paternal family. And the order then became like when the quote unquote father had parenting time, the aunt would have to be present, and she was supervising, but she basically managed the parenting for the whole family. They had a very, as he said, this is interesting. I like this comment where he says he accepted that they had a multi-generational collectivist family structure. And he, it's basically number of generations of family living together, right? And he acknowledged that that can present a number of benefits for the child. It wasn't as strong in this case, but it's a good statement to use in other, that many families don't raise their children just parent and child. Lots of families raise their children with grandparents and aunties and, siblings and that's how we raise family. And that's an important structure. It's not, this whole taking away from just focusing on the quote unquote nuclear family, right? So this is a nice statement of that there are benefits, in these kinds of bigger family units that should be acknowledged. So, and that's sort of, and the importance of, in this case, the importance of the paternal aunt was also because the father just wasn't in a position himself to care for the children, and the children had had a very strong bond with the paternal family until the separation. And the problem in this case was also that the mother wasn't very, didn't have good relations with the paternal family anymore, and so wasn't really allowing there to be a lot of parenting time. So, as I said, Justice Edelman again notes the tension between mother and paternal aunt and the other family members, and said, of course, it would be in the best interest of for the child if the paternal aunt and the mother supported each other in their respective roles. What he commented is that he was satisfied that the paternal aunt understood the importance of clarity for the child, so that the child wouldn't think of the paternal aunt as the child's mother. So there wouldn't be blurring of those roles and realities. And finally, in terms of, although the guardianship was granted to the paternal aunt, Justice Edelman still allocated the parental responsibilities to the mother, except that the aunt could make day-to-day decisions when the child was in her care or obtain information directly from third parties. But otherwise, the mother was allocated the parental responsibility. So there was no shared parental responsibilities. And that had to do with the tensions between them. This is an interesting case around an extension of a protection order. And the mother had previously gotten extensions, but they were by consent of the father. And this time, when they appear before Justice Tucker, the protection order wasn't agreed to by the father. And just to be clear, the protection order was only in relation to mother and not the children, because the father was not having any parenting time. It's not really clear why. I think obviously he's a bad guy and he wasn't able to see his children. And so the court granted the extension. And in doing so, the Justice Tucker considered the detailed evidence of the mother about severe abuse during the relationship, and noted that other than denying the claims of financial abuse, the father's affidavits really didn't respond to the mother's evidence about family violence. And so one of the comments in the, you often do, and this is an affidavit writing thing or an evidence thing that is important also for women, not just for men who are the abusers, but for women to realize that, I said this to my client the other, if you don't respond to something in an affidavit or in evidence, it's taken to be true. It's not controverted, right? So it's important to actually, we can't always do that. We don't always have the time. We don't always have all the information. Your client isn't necessarily, oh, shoot, I forgot that, right? But the blanket statement basically that, if I haven't responded to anything in the affidavit, I do not admit that it is true, right? So basically those kinds of statements that we often put in the front of affidavits, that sort of basically say, if I don't respond to it, that doesn't mean I accept that it's true. I might still come back and, challenge it later. Well, Justice Burke said, hey, it's not for the father to tell the court that, whether his failure to respond is an admission in the circumstances or not. So basically the caution here was, if you want to challenge a statement of fact by the other party, you better respond to it. But I don't know. Yeah, Sarah.
I've never heard of someone agreeing to a protection order. Is that something that happens? Like, I know for peace bonds, of course, because it's like a negotiating tactic a lot of times, but is this something that you've seen?
Not usually. No, and it seemed to be several times he agreed to the protection order. So, well, yeah, I don't know. I don't know enough.
Would it be something the judge would be saying to him, or I just can't imagine what would lead to that?
Well, it could be he just doesn't have the money or to fight it. He sees the evidence and it's just like, am I going to have and once there was one granted, it was the extensions that were extended, right? So some people do I've seen people, okay, I'll agree to extend the protection order. It's been granted and I'll extend it subject to, because we're waiting for example, the ministry reports or the police to exonerate me or something. And so that may be a circumstance that there is a consent to the extension of the protection order. Similar to like safety plans with the ministry, that sort of thing.
And do you know, were those extensions like for a year at a time, or was it a few months?
It seemed to be. Yeah. That's how they framed it, it was a year at a time.
Oh, wow. Because I mean, here, protection orders are rare and they're often just for short periods of time, like 3 months or 6 months.
Let me look at that again. Sorry, it's not quite in my head as to that, but I will. Damn it. I was like, you mean you expected me to actually read the case? There's so many I was going through.
I was just so shocked. I need to know more.
That. Good call. Yeah, how long it is. But that's an interesting point. Uh-oh. I'm in trouble. Sonia has a question.
No, it's not a question. I'm just saying I've actually seen this quite a number of times where I've had the abuser, sadly, invariably male, just say, I'll agree to it because, I'll be cleared. Like they're facing charges. And then once I'm acquitted, then, I'll be, my name will be like, things will, accusations against me will be dismissed, and they just agree to it because they think they're going to be cleared further down the road. But as we know, some of these cases drag on for a long period.
They do. And also on that, actually, thanks for pointing that out, is that if the abuser is involved in a criminal proceeding, they're often told they do not give any evidence in any other proceeding, because that can compromise your criminal proceeding, because you're going to be asked, did you do this, and so forth. So a lot of times they just won't actually say anything. It's just a sort of a general denial, but won't actually talk about the specifics of anything because there's an ongoing criminal proceeding. So that may be a case where, as someone says, they just also are told, just agree to it because you can't testify or give evidence about it while this ongoing criminal matter is, not resolved. Mm-hmm. But yeah, that's great. Thank you very much, both Sarah and Sonia, for that. I will have to look at that case again now. I hate when I get caught out. Anyway, so yes. So this was just, I was interested about it because it was just about this caution about if you don't, respond to things that's taken to be true. And I use this because it's not just if, sometimes, of course, a lot of abusers will level the same kind of, allegations, right? And so you kind of have to respond to things and not to say blanket anything he says is not true. I mean, I think that's what Justice Burke is saying. That's not satisfactory to us. So, but in this case, I think probably there's so much overwhelming evidence against the father that was, anyway, it wasn't an issue. Yes, because so here in outcome, Justice Burke says was satisfied that the father's failure to respond to, let alone refute, the incidents of family violence detailed in the mother's affidavit does constitute an admission that the incidents occurred as described. I've not really heard another judge say it like that, as an admission, but more that I I believe more what the mother has said in this circumstance versus if the father hasn't responded to it, it's an admission that in fact all this happened. Yes.
In a situation where the application is done without notice and then they have their 7 days to reply and they do nothing. I mean, I'm assuming that wouldn't constitute an admission in that situation.
I don't think so. I don't think so. I mean, as the courts often say, there are reasons for why people don't do things, right? And I think as Sonia was talking, realize, yes, one of the reasons is why if there is a criminal proceeding, you really, as somebody's being charged with something, do not want sworn statements anywhere else about certain incidents and so forth. You don't want to be put under cross-examination, for example, so because it can be used. So yeah, so I think the family courts recognize that.
You know, and because I also work with abusers, some of them just have too many disabilities and too many barriers. Yep. They just can't get it together to respond.
Right. Yeah, and that's a big thing, right? Yeah, I get that. Yeah,
Gary's back.
Hi, Gary.
How are you?
Good. Nice to see you.
Good to see you as well. Too bad we're not in person, so I can't get some saltwater taffy.
I know. I can't throw them at you. It's so sad. It's not sad.
I recently had a client show up with I guess an affidavit in reply from her opposing party that was over 20 pages of rambling nonsense.
Yeah.
And initially my goal was to respond to all the shit that was written in there. It was just unbelievable. Sorry to use the legal term, but so I guess in the end, client got real legal advice and had a lawyer, so I was no longer involved. But my question is, when you're faced with something like that, do you bother trying to respond to nonsense?
Yeah, I mean, so you have to sort of, first of all, you parse out what is opinion, argument, because you don't have to respond to any of that. If they're just rambling about, their opinion that your client is, so-and-so and this and that. But if there's sort of factual things that of any relevance, of any substance, then you should respond to it. But it's hard because oftentimes we're in such time crunches. I mean, as advocates, it's not like you can work on an affidavit for 10 hours or something and just, you probably get an hour and you're just like trying to get yourself through it. So I think that's why we include something like, if I don't respond to this, it doesn't mean I'm admitting that it is true. And I reserve the right to respond more fully if this is necessary. But often you don't get the time to respond more fully anyway. So you have to do your best and at least try to find the things that are the more significant, I guess, factual issues that you can challenge. And if it's simple enough to say, even if you say that's not true, that's not what happened, what does the court do with that? Just because you say something happened, it doesn't mean it's true. But I can't, if you say you and I, did something, whatever, and it's just like, we absolutely didn't, I was never there around you. Like, what am I supposed to say except I wasn't there? I don't know what he's talking about, right? You can't actually explain anything more than that. So, yeah, as best as you can, particularly anything that seems significant, particularly like if something, the other side says, that your client, swung an axe at them, you've got to respond to things like that.
Okay.
Right? Or beat the kids or did things like that or something. You've got to respond to things like that. But if it's sort of something minor, I don't know, then, but I guess at that point, you're responding to most things, right? So right. You have to think of things that would really hurt your case if the court found to be true. Accepted to be true or something. That said, somebody who's rambling on stuff like in affidavits, oftentimes the court would, wonder about their credibility and their reliability anyway. So,
yes, unreliable narrator.
Yes, absolutely, absolutely. Thanks, Gary.
Thank you.
So we're at 15-ish minutes before the end. Um, I'm just flagging that in case you want to pick your favorite.
Yeah, I'm picking. I'm moving along. Yeah.
But-
Okay. Anyway, this was the extension of the protection order, some of the grounds in which parental alienation. This was an interesting case. Justice Thomas, the child was 13 and a half years old and was estranged entirely from mother. And so the question was whether the child actually was alienated from the mother by the father. There was an expert report done by a Section 211 writer and talked about alienation. The report writer was Dr. Nicole Obey, who's now retired. So first of all, the court goes through, if you ever need to have a case that talks about admissibility of a Section 211 report, Justice Thomas goes through the tests set out by the Supreme Court of Canada and Mohan and White and Burgess about admissible expert evidence. And then the mother had a solid relationship with the child and was a primary caregiver until the fall of 2019 when everything changed and father got his hooks into the child and the child started distancing himself from the mother. And the court had intervened many times in terms of making orders for the parenting time, orders again for how the parenting time would go. And there were several attempts to use mediated reunification, which were unsuccessful. I think they had even tried some reunification programs. And the Justice Thomas found there was substantial evidence indicating enmeshment had occurred between the father and child. And so if you ever want to know what enmeshment is or a definition of enmeshment, this case sets that out through Dr. Obey, who talks about what enmeshment is. And one of the things is the child may have an exaggerated alignment with one of the parents at the expense of the other parent. And enmeshment is often present when there is a dynamic of alienation. I'm not going to read this definition, but if you ever, again, need something that sort of, there's not a lot of cases where there's expert evidence around alienation. This is a more recent case that goes through that. The court found that the father had alienated the child from the mother and that there was ongoing and long-term harm to the child as a result. So the court ordered a family bridges program, which involved removing the child from the favored parent, the father, to an undisclosed location for therapy. And the transportation would be done by a third-party professional to transport the child. So anyway, it's I don't know what all of you think of these kinds of programs or things like that. It's kind of like conversion therapy. I don't know. If you were the child, the 13-and-a-half-year-old child, I mean, anyway. So, but it just seemed to be, there was nothing else. They tried court orders. The father would bring the child. They tried some other therapy and counseling, didn't work. So this was where the court went with it. It's too soon to know what's happened with this case. And so basically said there was short-term harm and distress in doing that to the child. But then there's also ongoing and long-term harm by not doing anything to help restore the relationship between mom and child. And then the court also noted that there was already evidence of harm that the child was experiencing, in that the child had anxiety, his school attendance was inconsistent, and he had no peer relationships and activities. So the court could stand outside and say, it's not just the relationship between mother and son that was being put in jeopardy. The child himself was suffering harms by I presume it's all going to be attributed to the father and how the father was behaving and controlling the situation. So that's not necessarily a sign of alienation, probably because it's alienation from anyone else around, like the world. So if you've got that kind of evidence as well, it seems to lend itself to finding of alienation. So yeah, I haven't seen a case on alienation for recent, so that was kind of interesting to read. Just another case around family violence. Anyway, this was these parents, OP and JDP, Justice Donegan. It was a 17-year-old and a 12-year-old child, and both parties perpetrated family violence against each other and towards children. And there had been multiple protection orders and conduct orders. It didn't say who had which, but anyway, and then each party had to pay penalties to each other. I think the mother had to pay $3,000 to the dad, and the dad had to pay $2,000 at some point. So this had been going on for some time. The court found that the mother perpetrated physical, psychological, emotional abuse against particularly the party's older child, and that child actually testified at trial, and including speaking about the mother's violence towards her. And the court found that the child was a credible witness. And then the mother perpetrated emotional and psychological abuse because she and the father would fight, and they would call each other derogatory names, and this was all in front of the children. Similarly, the father was guilty of family violence as well. He surreptitiously filmed the mom naked and then posted those videos with other pornographic materials he was watching, and saved them, with other porn materials. He pleaded guilty and he completed a respectful relationships course. Anyway, but he didn't take responsibility for the impact of that on the mother. And again, he was involved in fights. So in the end, the court ordered that the older child would live with the father. The parties agreed to that, and that all the parental responsibilities would be with the father. The mother had asked for specified and limited parenting time, but given what the child had said, the court was not prepared to do that at the time. And then the younger child, who was 12, was going to have equal parenting with each, the mother and father, with the parenting coordinator to decide if they had disputes, because they would have disputes, no doubt. So the Justice Donegan made a conduct order prohibiting the father from filming the mother. The father said, I just want to film her breaching court orders. I won't film her naked anymore. And the judge is like, no, you can't even do that, because the courts generally discourages surreptitious recordings, and any filming of the mother by the father would be triggering and frightening to her. So this is a good one there's a couple recently that have talked about sort of the surreptitious filming or putting tracking devices on people and stopping that. So this is a good thing to use as this is part of family violence. But the important thing is just saying that the father may think it's benign. I'm just trying to, make sure she doesn't breach orders. And Justice Donegan is very clear is that what you did before has caused such trauma to the mother that it would trigger her if you were just even saying, oh, can we take a family photo? So it's important that, the court doesn't just look at the act, because that's often what they do. Is that family violence? Like, really, I'm just filming you walking down the street. Is that family violence? It's sort of looking that, look, what is the history that accompanies that in the context, right? And the impact on the actual lived experience of the person who is subject to that. So this is a good case for that, is that, because sometimes they say, well, you didn't really hit hard. So, didn't hit you on the face, hit you in the arm. Is that really violence? But we all know, that can certainly trigger things. Okay, a couple more. Let's do termination of guardianship. So the father sought to terminate the mother's guardianship of the child, and the mother had no contact with the child or the father since May of 2018. So we're talking about like 4 years. The mother didn't participate in the proceeding. This is in provincial court. The judge declined to terminate the mother's guardianship and distinguished the cases. And the judge basically said, it's insufficient evidence to show the parents would be incapable of co-parenting if they had to. There was no evidence of ongoing family violence or sexual impropriety, or that that would have negative impact on the best interest of the child. And this isn't like a case where an older adolescent child was saying, I want nothing to do with a largely absent parent. So oftentimes that's a ground in which the courts will terminate guardianship if a parent is really out of the picture. But Judge Galinsky, and I don't know if it was because it was a mother or who, why, and they didn't really say why the mother wasn't really around, what was going on for the mother, but just didn't want to close that status for the mom by saying that the mother's no longer a guardian. Of course, the father was allocated all the parental responsibility and clearly had all the parenting time, but didn't take that next step in terminating the mom's guardianship. So some courts will, after several years of a parent not being around, particularly when they say, well, but some people, if they say there's two guardians, they want the other guardian to sign, right? And so you don't want to get into any situation where you have to say, yes, there is another guardian, right? And that's why lots of times my clients will say, can we just terminate the guardianship? Because I don't even want to have to try to find the person or anything like that. Anyway, so this didn't, I guess, cross enough go far enough for Judge Galinsky to cancel guardianship. And said, you know, there's a myriad of reasons why a person does not participate in litigation, and I'm not going to speculate why that's the case. So this was a grandparent contact. You asked about whether, you know, grandparents have the right to contact, or whether it's really about the best interest of the child, right? There's two sort of streams of thoughts, that grandparents have the rights, or it's really about the best interests of the grandchild. And in this case, both the grandparents were Indigenous and the mother was not Indigenous. And sadly, the father of the child, so the paternal grandparent's son, obviously, he passed away. And so the mother was essentially blocking their relationship with their grandchild. The court found in this case that the mother was intentionally alienating the child from the grandparents. And by doing so, was also alienating the child from his Indigenous culture and heritage. And that wasn't in alignment with the child's best interests. Judge Archer said the child has a right to know his Indigenous culture and heritage, and the law shows that is important, that it is made accessible to him. You know what the law says so. And so denying the child's access to that culture and heritage is not in his best interest. And so how he would have access to his Indigenous culture would be through the child having contact with his grandparents. And so allowing the grandparents to have contact with the child would protect to the greatest extent possible the child's physical, psychological, emotional safety, security, and well-being. And by denying the child, no one is denying the child has Indigenous ancestry, and the child's connection to his Indigenous culture and heritage can't be separated from his relationship and with his grandparents, who were a very big part of the child's life until the rift between mom and grandparents. So they were in the best position to support him in what they call access to his Indigenous heritage, including the Nech'Totnach and Tsawwassen First Nations communities. And so in that case, sorry, just that the court actually then left it to the parent and the mom and the grandparents that could have worked out the access, the contact schedule. And COVID vaccinations, just quickly. There are a number of cases that come up with the same thing. It started out in Ontario first, sort of worked its way here. Judge Lee recently, well, this is early January, the mother wanted to vaccinate the children, the father did not. And Judge Lee said, hey, both parents love their children. It's not about one is a bad parent or good parent if, you know, the one parent doesn't want to vaccinate. It's just they just don't agree on this issue. And look, this is an issue that's been subject to debate throughout our society since the advent of the pandemic and development of vaccines. Good parents can have a difference of opinion. Because lots of times, you know, I have parents, and they're often moms who have concerns about vaccines, who get then vilified, right? Not just for that decision, but everything then, right? They must be whack jobs and so forth. So this is, good parents can have a difference of opinion. Anyway, in this case, though, he says, I don't have to analyze the scientific evidence about the vaccine. I can take judicial notice of things, right? And that's what the courts do with the COVID vaccines and COVID itself. So what the judicial notice that Judge Lee takes is that there's a pandemic and it's leading to health restrictions. Contracting COVID poses serious health risks to children and adults, and that the Pfizer COVID vaccine is safe for children and adults. And probably there are other vaccines now safe for children. That's what he takes judicial notice of because the health authorities have said so. And then he says there's these various principles, right? Just because there's a not universal and mandatory COVID vaccination requirement doesn't mean that vaccines are unsafe. And he takes judicial notice of the effects of COVID, including a risk of serious illness and death. And again, that judicial notice that they are safe compared to COVID itself. Having a vaccination is in the best interest of the child, and waiting and seeing is not in the best interest of the child. And these are rebuttable presumptions, but unless you have actual scientific, so the court will take judicial notice of this, they won't take judicial notice that we don't know all the science yet and all the evidence. So if you want to challenge that, you would have to have some actual science to back it up. Anyway, so ordered that the mother will have the parental responsibility authorization to obtain for the children COVID-19 vaccination. Now, again, this is a case similar to school where the court doesn't say you have responsibility over all healthcare. It's just specific to the vaccination. So if you ever get in that situation, you really have to stop, try to stop the court from giving like, here, you get the blanket healthcare, right? No, it's just, you can make the decision specifically about COVID vaccinations. And then these are a number of other cases that also essentially say the same thing around COVID vaccinations. And then we can end, this is my last one. Do you have 2 more minutes for me?
Looks like it. Is that
Okay.
okay, people? Looks like it. Let's go.
This is kind of, it was just kind of an interesting one. I like Justice Schultes generally. He's got some good, he writes well and stuff. Batul and Siddiqui. Anyway, the wife had obtained the wife mother had obtained an order to serve the respondent by subservice, email, WhatsApp, and to the address of the respondent's son from previous marriage. And then, so the service was done. The respondent never filed a response to family claim. And then in August, a year and a half later, no response, the claimant gets a final order in chambers. Essentially, it's like an undefended notice of family claim. But it's like terminates the respondent's guardianship. Sorry, I should say the respondent was living in Pakistan. Terminate the respondent's guardianship. He was had no contact with the child unless he made a court application. Imputed income of $45,000, and then his child and spousal support obligation would have to be paid out of essentially money that he would get from the family property until those funds ran out. So then the respondent sought to set aside the final order, and the court noted, yes, the court can set aside final orders that are obtained in an undefended proceeding, even though she did have to appear in chambers. It was still undefended because of it had inherent jurisdiction to prevent what they call miscarriages of justice. So here's the test on how to set aside an undefended final order. Did they willfully and deliberately fail to reply? Did they, as soon as possible, seek to set aside the order? And also that they have a meritorious defense or a defense worthy of investigation. So it can't be a frivolous claim. So clearly he didn't reply. The court wasn't satisfied that he didn't receive these notices of family claim because he got the order through WhatsApp anyway. And anyway, so the court didn't accept that the respondent met the requirement, number 1. Number 2, though, he accepted that the respondent took steps as soon as possible to set aside the order. He got the order February 2021, and the respondent said he couldn't get a flight back to Canada till September 2021, and then he filed his application the month later. So that was fine. And then the requirement number 3, Justice Schultes found there was the respondent had a defense worthy of investigation because the debts were all attributed solely to him, but they could have been family debts. His income was actually lower than what was imputed to him. And then finally, of course, it may not be in the child's best interest to have such restrictions on the respondent's parenting involvement. So this is the caution of don't ask for too much on an undefended. You got to be cautious about that because it may come back to bite you. And so, so he said that the weight of the two other prongs meant setting aside the order was required in the interest of justice. That said, Justice Schulte said his inaction does him no credit, but the manner in which the final order disposed of his financial interests and his parenting role is so comprehensive and has sufficient arguable flaws that it would be unjust to prevent him from arguing in favor of a more balanced outcome. And so he set it aside, gave the respondent 30 days to file, and also awarded the respondent costs of the application. And that is it for today. Yes, I hope some of those were interesting cases for you folks. I tried to pick some that, a broad range of them and things that I try to recall what we previously talked about. And although I know I don't see you all every year, but try to add to all our knowledge base with that. So,
well, thank you. Yeah, I'm seeing things in the chat that people are grateful for. And a lot of them are topics that I know people are dealing with in their work. So thank you, Agnes.
You're welcome. And as I've always said, and some of you, only a few of you take me up on it. If you ever have any questions, if you run anything by me, you are more than welcome to call me.
I just wanted to, I didn't say something at the beginning, I probably should have, because I know there are a few quite new family law advocates on here. And I just want you to know that this is to give you, intended to give you an overview of the issues. Please don't think you have to know the ins and outs of family case law, because we've got Agnes. But just so that you keep it in perspective, and especially if you're new. But thank you so much. And the materials are now up on Shed. So if you want to go back and review what Agnes talked about, you can do that there.
Oh, I'm going to clean them up, and I'm going to add this lovely other Supreme Court of Canada case. And
Okay.
I have a few more I want to add that I didn't have, I knew I didn't have time for, but there was a few I was like, oh, I should put those in. But yeah.